There's the affidavits. There are a bunch of them. I like getting lots of affidavits.
Whoa. I swear it's all true, so help me God.
Can I just tell you that this was stuck in most of the binders, but some people didn't get it. It's a new letter we've written.
Okay.
It's about
I'll mention it right now. Okay, we are going to continue now with Donald. We have amended the agenda to try and take into account all the time that we lost this morning. And we have decided to eliminate lunch. We are going to have sandwiches brought in. Oh, please sit down. You want to swear this? Okay, everyone is sitting down, and now we are going to continue with exclusion. And we'll do that after. And I've already introduced to you Donald MacIntosh. And he's going to tell us how he managed to convince the federal court to rule the way it ruled in Ramirez. No. I'm just teasing. All right.
Can everyone hear me?
Yeah.
First of all, I would commend to you Gregory James' paper. It's an excellent paper. It's very well written. It covers most of the areas that are certainly unclear in this area of the law. I think that it may be useful for you in considering Article 1F of the Convention. And indeed, in considering many issues in the Immigration Act, to go back to first principles and look at some of the sections, such as Section 4, which provides that of the Act that a Canadian citizen and a permanent resident have a right to come in here. There's also Section 5, which says in what circumstances it's a privilege to enter Canada. And you should also keep in mind that under Section 8 of the Immigration Act, the burden of proving admissibility falls upon the person who's seeking entry into the country. And so when one is judging the exclusion clauses and whether or not they should be given a restrictive interpretation, one has to judge that against the backdrop of provisions such as Section 4, Section 4.21, which deals with refugee claimants who have a qualified right, not an absolute right, to enter Canada. And I also think that you may want to keep in mind that the Charter of Rights itself, in Section 6.1, makes it very clear that a Canadian citizen has a right to enter or remain in Canada, but it doesn't say anything about anybody else having such a right. That omission was significant in the recent Supreme Court of Canada decision called Shirelli, where a permanent resident was deported from Canada. Now, in looking at the convention, Article 1F, you can see, as Gregory has mentioned in his paper, it's worded in similar terms to 19.1J of the Immigration Act, which is Section 19.1 is one of the sections that deals with people who are inadmissible. And 19.1J specifically deals with people who there are reasonable grounds to believe have committed war crimes or crimes against humanity. And in Ramirez, one of the arguments that I made on behalf of the Minister of Employment and Immigration was that it would be inconsistent with the interpretation of the Convention and the overall policy of the Immigration Act to interpret Article 1F in a different fashion than 19.1J. And I must say, quite surprised that the federal court decided to say that the standard was less than the balance of probabilities, because as litigators we all make arguments, and sometimes we're shot down in flames, and other times we get a different result. But these issues that have been raised in the paper today, which is excellent, this is a very problematic area of the law, and these issues are far from clear. And for example, take the issue of the whole question of superior orders. If one goes back to the London Agreement, which is the agreement that set up the International Military Tribunal, it's fairly clear from Clause 8 that you can't plead a defense of superior orders. Some commentators disagree with that. I think if you look at the criminal commentators, people like Glanville Williams, Don Stewart, they all say that superior orders is not an absolute defense. However, even in Article 8 in the Nuremberg Charter, it does indicate that it can be used in mitigation, of penalty, although it's not an absolute defense. So, under the convention, you get into this large question of whether or not, to what extent there can be mitigating factors, and do those factors have to be balanced. And we don't have time to really talk about that today, but I would encourage you to keep in mind that when you're arguing before the board, if all else fails, maybe I shouldn't say if all else fails, maybe this should be one of your first lines of attack. Use the Charter of Rights. You know, this is what it's here for. Don't be afraid to argue that different sections of the Immigration Act are unconstitutional. People like Barbara Jackman and Lorne Waldman, both of whom I have a lot of respect for, frequently use the Charter of Rights on behalf of their clients, both in front of the board and at other levels. So keep in mind that probably next to criminal law, immigration law is one of the fastest growing areas in terms of charter claims. Now, as far as the Ramirez case is concerned, let me just tell you that the Federal Court of Appeals said that the majority, or the court said that Mr. Justice McGuigan, writing the majority judgment, said that, or the judgment for the court, that it wasn't a close case. But that wasn't my impression, the way the case proceeded in the federal court, because certainly they, in terms of the facts, they gave me a very hard time at certain points in the argument, and I was surprised a couple weeks later to read in the judgment that in the court's opinion it wasn't a close case, because I didn't have that impression going through the argument. This was a man who...
Oh, you're going to do the facts now? I was just going to ask you to do the facts quickly.
Sure,
Yeah,
sure.
okay.
This was someone who was a sub-sergeant in the Army, and one of the things he did was stand guard outside a hut while people were tortured in this hut. And there was a question as to whether he was standing guard as part of the normal military watch, or was doing that with a view to aiding or abetting the commission of various offenses. And Mr. Justice McGuigan was not satisfied that he was standing guard with a view to aiding and abetting, as opposed to just taking normal military watch. However, he did participate in enough other activities and going out to the fields and rounding people up that, in essence, what the court did was sort of to apply an analysis under Section 21(2) of the Criminal Code without really calling it that, and say that he had formed a common intention with the people in the Army who were committing these various atrocities. I will just tell you that I participated in the Rudolph case, and if Ramirez is not a close case, then Rudolph is overwhelming, because Mr. Rudolph was someone who was in charge of the slave labor program in Middlework and had 4,500 slave laborers working under him in the most brutal conditions imaginable. These people had to get a ticket they were forced to urinate in gasoline drums. So the Rudolph case was really the first case decided under Section 19(1) of the Immigration Act by an adjudicator, and the Federal Court of Appeal upheld that, and indeed in the decision, interestingly enough, said that the adjudicator had placed too high a standard of proof in the government. So in looking at the exclusion clause, you should also look at 19(1) and these other sections that I've mentioned, because they are interrelated, and 19(1) will assist you in looking at the exclusion clause. And As Gregory has mentioned, people like James Hathaway and Goodwin Gill have written some excellent material in this area. Thank you.
Thank you, Don. Lori?
Hi. Can you hear me?
No.
Is this on?
Yes.
Okay. All right. Better? Okay. I'm going to keep my comments brief in response to Greg's paper. I also don't want to be accused of being the one responsible for you missing lunch. Ramirez is really the only case we have right now on the exclusion clauses and the standard of proof and the onus of proof. And the case has not drawn a line in the sand, so to speak, because there are a lot of issues that need balancing and weighing in the final analysis. But what did come out of that case, it was very clear, was that the burden of proof is on the government, so that if all the evidence on both sides is even, the government has not discharged its burden. The other very clear item was that the standard of proof is less than a balance of probabilities. What really troubled the court in Ramirez was the issue of an accomplice. What is an accomplice? And they came up with a phrase that to be an accomplice, you have to have personal and knowing participation. The court went on to discuss what is personal and knowing participation. A couple of statements were made. One was that mere membership in a group isn't enough, prima facie, to make you have personal and knowing participation, unless that particular group, when you joined it, had a clear mandate and it had a clear goal of persecuting groups or had a brutal purpose. In that case, mere membership in such a group, such as a death squad, for example, could be enough to be personal and knowing participation. On the other hand, add to that the fact that the court said that just being an onlooker is not enough. But if you add being an onlooker with membership in one of those specific groups that have a brutal purpose or a persecutorial purpose, that together may be enough. And that's all the court was willing to say. It said it won't go any further than that because the facts in each case have to be decided as to what constitutes personal and knowing participation. And in the case of Ramirez, he was a member of a group, and he was an onlooker. So the question is, what kind of a group was this that he belonged to? Was it brutal purpose? Was it persecutorial? And the length of time was also a major issue in this case. It's how long he stayed being an onlooker in a knowing way, knowing what went on, belonging to this group, knowing what went on, how long did he stay here? So there are a lot of factors. It's not cut and dry by any means in terms of what is an accomplice, but the membership in the group, the kind of group is a factor, the length of time is a factor, and being a mere onlooker can in fact qualify you if you know what's going on in that group, if you know what's happening. There are just a couple of things I wanted to comment on with respect to Greg James' excellent paper. One was that he it was good. I started my whole research with his paper. One of the issues that seems clear from the handbook is that when you are dealing with a section B, serious non-political crime, 1FB, that the handbook does suggest that you balance, that you take a look at the harm feared, the persecutorial harm feared if you do go back to your country of origin, against the nature of the crime committed, and that there's some balancing that goes on, and perhaps if the nature of the persecution outweighs the seriousness of the crime, then the exclusion clause won't be applied. There's no authority for that, but the handbook does talk about it. So the handbook is not binding, but it can be persuasive. there is, I think, a very obvious omission of that balancing test when the handbook talks about war crimes and crimes against humanity. Excuse me, humanity. It's just not there. And I think it's not there for a reason. I think that war crimes and crimes against humanity are considered such serious, grave acts against all of mankind that, excuse me, the issue of balancing shouldn't even enter in. If there are serious reasons for considering that somebody has committed a war crime or a crime against humanity, it should be exclusion. And Hathaway, in his book, talks about the discussions that went on in the drafting of the article, and that the United States did object to it not being discretionary, the exclusion of war criminals not being discretionary. And at the end of the day, the American position did not win out. And so Hathaway is also of the view that there isn't, once you pass the threshold of serious reasons for considering in terms of war crimes or crimes against humanity, there probably isn't any balancing and that there is exclusion. The other issue that Greg talks about, and that's also mentioned in Ramirez, is the issue of duress. Ramirez doesn't talk about superior orders, and generally speaking, that's not an acceptable defense for war crimes and crimes against humanity. But the issue of duress is raised. And the court says that the law doesn't function on the level of heroism, that there isn't the expectation that somebody do heroic acts when asked to commit war crimes. But on the other hand, he says that you have to look very carefully and that the international law requires a choice by those placed in a position of committing international crimes. So duress might be a factor, but you have to take a look at how serious was the crime this person was asked to commit or did commit, and how serious were the consequences for him if he said no. And that's something that was a problem for Ramirez as well. He was a knowing participant, a knowing personal participant in torture and murder. And he said by his own admission that the consequence for him for disobeying this order or for not participating in these activities would have been really hard training exercises and being thrown in jail for 5 to 10 years. Well, the court balances and finds that an insufficient reason, and that is not duress. So there is balancing as well going on within in saying I want to refuse these orders. The court will take a look at what punishment did you face, what potential punishment did you face by refusing to go along with the international crime. I think that's it. That's all that I wanted to comment on with respect to what Greg had said. Actually, there was one other issue. On page 9 of Greg's paper, he kind of raises an open question, which Grahl-Mattson raises as well, as to whether the preamble of Article 6 of the Charter of International Military Tribunals in fact, is that to be limited to the Nuremberg trials, to the European Axis countries? And Grahl-Mattson asks that question, but he also answers it in the affirmative that, in fact, it should apply now. And I would suggest that the fact that Article 1F itself incorporates these instruments, these international instruments, by reference within the article itself to these instruments, it makes them current and applicable today. Thank you.
Now, we don't have a lot of time for questions, but I want to raise something for the panelists. This occurred to me, and it has to do with the role of counsel in this whole question of exclusion. And it has to do with what counsel does when his client is sitting in his office and you're preparing the case, and the client starts telling you things that you don't want to hear. Now, I know that the board people are all in one room, so I'd ask the technician to shut off the microphone, because this is a discussion for counsel, okay? No. I was teasing. He was joking in there. He's got a sense of humor, that guy. Now, no, the question really is, what is the role of counsel? You're counsel for the claimant, but you're confronted with this person who starts telling you all these things. And what's your obligation? I'm asking the panelists to respond. I wrote. They're not being taken totally by surprise. I wrote them a note and I told them that they're going to be asked this question. First of all, I mean, what's your role as counsel? Your client starts telling you these things. I mean, are you under an obligation when you go to the board to ask your client and bring this out? No. Well, if you're not under that obligation, what do you tell your client in terms of how he should present his or her evidence? I mean, certainly you can't tell him to lie or mislead, but, you know, can you suggest that he shouldn't volunteer it unless asked? When you're in your preparation of your client, obviously it's very important, if you see exclusion as an issue, that you tell your client that it might be an issue. And then how does that affect your preparation of your client in terms of the evidence? I mean, these are very important issues. When I read Ramirez, I mean, I get a sense that, I mean, maybe I'm totally wrong and it's totally unfair, but I mean, even if, I mean, the sense is that maybe the lawyer was taken a bit by surprise at the issue being raised in the matter it was, and perhaps if Mr. Ramirez had understood more completely what was at stake when he answered his questions, he might have been able to clarify certain points. And these are difficult questions, ethical, legal, and otherwise. And I think I'd like the panelists to. I mean, I have my answers. But I mean, I think we have to be aware that you're going to, someday you may be sitting across from some client who starts telling you things, and you have to know what your obligations are, both to the system and to your client. So we will hear from, in order, 1, 2, 3, if you have comments.
I guess this goes back in a way to my comments off the top, where I was talking about adverse, or at least admissions against interest. Where this perhaps is most acute is in the personal information form, when the question asks, has your client ever committed, or have you ever committed an offense? My answer to that question is that the lawyer is not under any obligation to advise anybody of the facts. The client, of course, cannot lie, and if an offense has been committed, then I suppose the client has an obligation to put that on the form. But as counsel, you're an advocate. And as an advocate, there may well be arguments available to you which say that the person has not committed an offense. And if you have a position to take which says that no offense has been committed, then that should be the position that's reflected in the evidence that you present and in the personal information form that you assist in the preparation of.
Or do you say no with an asterisk and then explain why, or do you just say no?
No, I would say no. If your position is that the offense which the person may allegedly have committed. Now, if they've been convicted, and I think the question says something about conviction, so that sort of removes your choice. But
does anyone have a personal information form here? Does it say? Oh wait, it's in the regulations. Does it say convicted or commit?
It says. I think it says both. So if there's a chance the person has committed an offense, and your position is that the person has not committed an offense, then I don't see there being a difficulty with that position being reflected in the PIF without an asterisk. You're an advocate, and the PIF is disclosure of your client's case, and your client's case is that no such offense was committed. And I don't have a lot of difficulty with that.
Okay. Now, what about in terms of getting past that point? What do you advise? How do you advise your client if it? I mean, obviously you can't tell him to lie. We all know that. But what do you advise your client in terms of how to give his evidence? I mean,
just to sort of talk in general terms as well, it's worth remembering that the onus is on the minister to present this evidence, to present this case. And moreover, there are ramifications outside of the hearing room, outside of this particular process, as far as the criminal code goes and extradition law goes and so on, which you also have to bear in mind. And your client has rights which you should be trying to protect without leading your client to mislead or lie to the tribunal. With respect to evidence, I would advise the client of the ramifications of the evidence, advise the client what the issues are, hopefully do it in a way that this client can understand, and the client can draw their own conclusions.
It's in the regulation. Yeah. Well, I mean, my problem is, I mean, in a criminal case, I mean, I'm not a criminal lawyer. A criminal lawyer, your client says, your client says, and you say, no, please. In this case, I don't think you can do that because of the nature of the process. You need to know what might come out because it's not an, it's.
More dramatic than that. In a criminal, if it's a criminal case, you can then take the position you won't put your client on stand.
Right.
That's right. Exactly.
You've got that choice here.
No,
The question becomes an ethical one. You want to hear the story, and if so, what do you do with it?
yeah, you almost have to hear the story the client has to give because you don't, particularly if your client gives testimony first, you don't even have full disclosure of the Crown's case. So you have to know so that you can present the mitigating circumstances in your evidence, if there are mitigating circumstances, right off the top. You don't have an opportunity to come back later and present that evidence. So you almost have to know what's going on. It's very difficult to say, don't tell me, I don't want to know.
Okay. Now, all right. So obviously that
I'm-
affects how you prepare in terms of like you explain to the client what the exclusion, what the issues are, and in terms of any evidence vis-a-vis mitigation, you explain, so that he can
Yeah,
present
see,
that.
Lorne says that this isn't a surprise to us because he wrote it down on a piece of paper. I would have liked 2 weeks' notice.
Well, it just occurred to me as I was listening.
I'm sorry, what was...
Well, okay. Well, I'll let you off the hot seat, and I'll put
Thank you.
Donald on the hot seat. No, this is the view of the department. No, this is Donald's own personal view. He used to be a defense counsel, right? So he's going to give us his view from that point of view.
Well, nothing I say is the view of the Department of Justice.
We
so
know that.
I have to give that disclaimer.
I'm just teasing you.
I think that, well, first of all, you have to have regard to the rules of the board, which are very specific and talk about a crime that someone's committed, an offense that someone has committed. And as is clear from the paper that's in the materials, this clause can be invoked in cases where someone hasn't been convicted of committing an offense. So I don't really think in a case where I don't think it's the function of a lawyer to prove the case for the Crown. I don't think that. I think you should try and take a restrictive interpretation of the rules, and if you feel that it's not a violation of that rule because of the fact situation, you're dealing with a set of facts where your client hasn't been convicted of anything, so it doesn't fall strictly within that rule, then I think that you're entitled not to disclose that. However, having said that, it may be that there are tactical reasons why you wanted to disclose it because you want to bring that out in evidence and put your own interpretation on it. In criminal cases, of course, if someone testifies, as you know, in the examination in chief of one's client, it's not uncommon for the lawyer to put his or her own interpretation on that criminal record through that client's mouth before the Crown has a chance to ask him about it. And I would think that it would be useful to employ a similar strategy here. I would also think that one would have to consider that board members, in most cases, are not lawyers, and they may have a view that either counsel or his client was trying to hide something in a particular case by not making the proper disclosure. So I think it just depends on the facts of how bad the facts are and what your sense is of the panel. If the panel is comprised of lawyers, then I would think it would necessarily follow that they'll be prepared to take a more legalistic or technical view of it, and you can probably pursue a different strategy than than if the panel is comprised strictly of lay people.
Do you have any comments?
No, there are a couple of issues. One is that, well, obviously on an ethical point of view, you can't counsel your client not to answer questions truthfully at a hearing when it comes out to exclusion clauses and so forth. So while you may be able to limit some damage by what you don't have in the PIF, because the PIF doesn't have to be the whole case, things are going to come up at the hearing through the questioning by the RHO. And if you aren't prepared to deal with the exclusion clauses and to deal with this issue, and at least to be able to present to the panel all the issues that go into knowing, participation, and accomplices and so forth, and address those issues, I think you're putting your client at excuse me, at a disservice. The minister doesn't always intervene in these cases, and if the so from the onset, I mean, the minister may not, if it's not in the PIF, the minister may not know and may not intervene from the outset, but it's clear that from the Batty-Bacoli case that there's no question that an RHO, during a hearing, if exclusion clause issues come up, can adjourn and ask the minister to intervene, and then it becomes an issue. But if they don't, if the minister decides not to intervene, or the panel decides not to adjourn in order for the minister to intervene, council has to be ready to go ahead on these issues and to deal with these issues.
I agree with you, but this is a very strange situation that council is in, because as the federal court notes in Ramirez, more often, in almost all of these cases, the minister won't have any extrinsic evidence that doesn't come from your client's own mouth. It's a really strange situation, and I don't really know what the answers are, but I think all of us who deal with these cases have to start thinking about the ethical questions that come, because the court says in Ramirez, I mean, the Canadian government doesn't have a catalog on every war criminal in the world. I mean, we have enough trouble getting rid of the ones we have in Canada right now. So I mean, and quite frankly, there are lots of heavy ethical questions that flow from the fact that you, as the lawyer, are putting your client on the stand in which he's probably going to hang himself, and you may know that in advance. And how do you deal? And how you deal with that? What is your duty to your client, and where does your duty to your client end, and your duty to the system begin? I don't know, and maybe someone else can give us an answer. But it's an interesting dilemma. Look, we can only take a few questions, and then we have to move on because we're already eating into your lunch. They're all looking very hungry here. So, okay. You.
Could I ask this question? Section of the question 29, it asks questions about whether or not you have committed or been convicted of any crime or offense.
Mm-hmm.
I'd like the panel's comment generally on whether the minister is allowed to ask questions that normally other, for example, employers are not entitled to ask. Both before the charter and after the charter, there have been a number of cases that have dealt with the right and entitlement, for example, of an employer to ask a prospective applicant for employment whether he's been convicted of a crime. But they're certainly not entitled, and the law is clear in the area, but they can't ask the question, well, have you perhaps committed an offense? Why is the minister allowed to ask questions that perhaps others are not
Okay.
allowed to ask?
The question for those of you upstairs and whatever is, can the minister, I think the question is fair to say, is a person compellable to answer questions with respect to the commission of not convictions? We agree that convictions, yes. But given that there have been charter cases that say that a person isn't compellable to answer questions with respect to commission of offenses for which there's no conviction, why in the refugee situation would a person be compellable, or is in fact a person compellable in those situations? Donald, the charter expert.
Gregory wanted to.
You want to go?
Gregory wants to go first.
No, I want Donald to go.
No, he wants Donald to go first, and then if he did.
I don't want to go at all.
Well, I think, first of all, the obvious approach is to, there are sections in the Immigration Act that, even at the port of entry, that make someone, in effect, a compellable witness, such as Section 12.4. That's fairly consistent with the scheme of the Act, which provides that one has a duty to answer questions posed by an immigration officer. Obviously, there is no right to remain silent for someone in the position of a refugee claimant, and the specific rights in Section 11 in a case called R versus Wigglesworth that was dealt with by the Supreme Court of Canada wouldn't really apply. So you would have to argue Section 7, and you would have to show that it's it would be a principle of fundamental justice that that this person not have the right to answer such a question. I'm not sure that I can give you a clear-cut answer. I think, like a lot of things in the charter, this can be argued both ways. I think it's far from clear, but the scheme of the Act, of course, places the burden of proof on the person to prove that you're admissible to Canada. And it's arguable that since you don't have a right to enter or remain in Canada, the Charter itself provides that only a Canadian citizen has that right, that you should have to provide such information.
But there's a difference between the issue of admissibility that arises during the course of the inquiry, which would be war crimes 19(1)J, Rudolph, right? And the issue of exclusion, which arises during the course of a refugee hearing, where the burden of proof was on you to prove inclusion, but the burden is on the minister to prove exclusion. And the question really would be, within that context, is a person compellable to provide information which is going to result from his exclusion after he has or she has established inclusion? Well, I think the answer is we don't have an answer. But it's Section 7 that you would have to rely on and say that fundamental justice cannot compel you to give evidence that's going to result in your exclusion. The argument against that is that you're seeking Canada's protection, and Canada is entitled to demand that you come with clean hands when you're seeking that protection. I think those would be the two ways it could be looked at, very simplistically.
Well, I think that you have to keep in mind that in the motor vehicle reference case, the Supreme Court of Canada set out the standard for determining what is a principle of fundamental justice, and you have to show that it's a basic tenet of our legal system, either in common law or in international law, that one have certain rights or protections. And it's certainly not a basic tenet of our legal system that someone in the position of a refugee claimant, either at the credible basis stage or later on, has a right to remain silent.
Yeah, okay. I think yeah, well, that's a separate question. Yeah, I mean, what the comment just was is if you don't disclose something and it comes up later, you can be removed under Section 27 for misrepresentation of a material fact, even after you've got you've been accepted as a refugee, or they could apply for cessation of refugee status on the basis of misrepresentation as well. Okay, I'm sorry. I know there's 900. Oh, I was going to call it, but Maureen has the last word. Oh my God! Can someone repeat that?
I'll let you answer that.
Well,
You're the one that appears in front of them all the time. You could feel that.
Well, I mean, the question is, we'll do it in parts. Given the fact that the burden of proof is on the minister, given the fact that in not all cases the evidence is of exclusion comes from the person's own mouth, and given the fact that there's no formal rules of evidence, what type of evidence would then be necessary in order to establish exclusion if it didn't come from the person's own mouth? Well, that's interesting, because I mean, what you're raising there is the whole question of the fact that the board isn't bound by the formal rules of evidence, and that they could probably bring forward the type of evidence that may well be excluded in criminal prosecutions. Documentary evidence, affidavits sworn abroad, and all sorts of stuff like that might raise the question of exclusion in a less formal way. I mean, if you're confronted with that kind of situation, obviously you have to ensure that your client's rights to meet to full answer and defense, even within the context of exclusion, are met. And even though they're informal rules, if they're seeking to file some affidavit sworn in some distant country and you have absolutely no access to that person to cross-examine, well, I mean, there's an element of fairness there that has to be respected as well. But I mean, that's certainly a possibility that the board could accept into evidence the type of evidence that could not be filed in a criminal proceeding, because it's not bound by the same rules of evidence that are in play in a criminal case. Yeah, of course, yeah. Craig is just pointing out that Section 7 would come into play, and the fundamental justice would still have to ensure that your client had a right to defend him or herself against some allegations that might come from some distant country. But that's a good point. Okay, now we are going to the panel is missed. I want to thank this panel, and Donald, Lori, Greg. And you don't move because we are going to mystically transform ourselves into a new panel, which is on persecution. And we're going to combine the two papers into one and do them right now. And then we'll have to figure out how we're going to organize the afternoon. Okay? So the three persecutions, we are now going to persecute you for a few minutes. I try to lighten things up a little bit here. Oh, while we're going through this metamorphosis, Jerry Sadoway from the Canadian Centre for the Victims of Torture wanted to make sure that you got the new June 12th letter, which tells you how you can refer clients to medical practitioners. Now, it should be in your materials. If it's not, there are extra copies available outside on the side desk. You should be aware that there are dedicated doctors, and no alliteration intended, dedicated doctors who are willing to see your clients to assist in providing evidence that can confirm or at least raise a strong inference that your client was tortured, both in terms of the psychological impacts of torture and also in terms of the physical sequelae. And that's all done through a referral service that is coordinated by the Canadian Centre for Victims of Torture, and it's all set out in these material here. Okay, we have to move on ruthlessly. You know, there is a comment sheet here. I really appreciate knowing whether you think this is too much, you know, and we should have tried to do a little bit less next time, but if there is a next time. The reason why I did it we did it this way was because we wanted to give you as much exposure to as many of the key issues as possible. Maybe the downside of that is it's too much, but so I'd really like to hear from you. You've got this critique in there. Okay, we have a whole new panel. We have metamorphosized, and we have Gladys MacPherson, who is practicing with Barbara Jackman and company in Toronto, and she's going to talk about cumulative harassment, and then she's going to metamorphosize because she has a personal commitment, so she's going to disappear whenever she has to. And then Clifford Luyt, who is an old friend, a lawyer in South Africa who's been working with me for many years and doing cases and helped me with the book I'm in the process of writing on the refugee chapter, and he's going to talk about persecution, prosecution, and then Sam Laredo, who's what is your title now this week? You were something else and you've now become back, right? Who is from the board, and he's the director of hearings for all of Canada, and he's in charge of, I guess, the hearing process, the refugee hearing officers, and all of that for the Immigration and Refugee Board in Canada. But he is based in Toronto, because that's where most of the hearings are held, so it made sense to have him in Toronto. So we're going to go 1, 2, and then Sam will comment on both of them at the end. And then we will have lunch. S'il vous plaît.
Thank you.
You have to be close to.
Do I have to? Okay, everyone can hear me. Lorne asked me to speak about cumulative harassment, and I didn't realize at the time that most of you may think that you are living it today, given that you all probably had to be up very early to be here and to fight the 401 traffic and to stand through lineups to get registered and to have your coffee break taken away and then given back and to be now threatened with loss of lunch. However, I assure you, your problems and you are not what Grell Modson had in mind when he talked about all those small annoyances which may add up to cumulative persecution. I define cumulative harassment in the following way. Cumulative harassment occurs when a number of acts of harassment or discrimination happen on account of one or more of the 5 enumerated grounds in the definition, which, if taken separately, would not be sufficiently serious to constitute persecution, but taken together create fear and insecurity within the mind of the person concerned, such that the cumulative effect of the various measures and restrictions amount to persecution. Now, I want to begin with just a few general remarks about persecution, although this is a fairly a specific topic or subset of the whole area, which is a huge area. It's like the last paper that was covered. My paper begins with that phrase, well-founded fear of persecution, and I don't really intend to follow the paper all that closely. I want to really start with the part of the definition which talks about how the person is unable, or by reason of his fear, unwilling to return to his country of nationality. Because that certainly suggests that the person that you are dealing with has such a fear that something very severe and something very grave has happened to break the relationship between himself and his state or his home country. There are therefore two main issues that you have to decide. First of all, is the harm which the person fears sufficiently serious to amount to persecution? And secondly, if it is it on account of one of the 5 enumerated grounds? Now, this paper deals with that first issue. Is the harm sufficiently serious? And the reason why I touch upon this before I actually get into my comments about cumulative persecution is the fact that I believe in Canada we have become preoccupied with the requirement that the persecution has to be persistent and sustained, and that there has to be established a pattern of abuse before what you have amounts to persecution. The board over the last few years has, it seems to me, made this a requirement that persecution has to be systematic and sustained. I keep wanting to say pressing and persistent, but I think that's what you talk about when you talk about hookers, right, in this country? It just keeps coming to me. The boards, of course, the boards do not operate in isolation, and they're getting their views and their guidance from the federal court. And although I must respectfully disagree with what the federal court has told us, there's no question that the position I'm taking is one that is not accepted in the jurisprudence as it stands today. And this all begins with the case in Rajadeen when the board went to the dictionary to define what amounts to persecution. And as recently as last year, Mr. Justice Marceau, in a case called Valentine, talked about how you need repetition and relentlessness. These are the elements that are found at the heart of persecution. Well, as I say, I must respectfully disagree. I believe that there are some violations that are so sufficiently serious and grave that they can amount to persecution, having happened only once. And in my paper, you will see reference to a CRDD decision which came down, I believe, late last year, in which the panel decided that rape was not persecution because it only happened to the claimant once. And the decision went on to talk about how it was an isolated incident, how the victim was a victim not of persecution but of circumstance, and gee whiz, isn't it too bad she was just in the wrong place at the wrong time. Now, there is another decision which I came across, which comes out of Pakistan, in which the board determined that rape did amount to persecution when added to all the other various forms of discrimination that the person had experienced. And in that case, they basically were looking at the cumulative effect of a number of smaller and lesser harms, and then they married that up with what I would consider a very grave and important harm, and they found that in that particular case there was persecution. It's my position that something as intrusive and as horrifying as sexual assault is in and of itself sufficiently severe to strike at a very basic core human right, and that it should be able on its own to amount to persecution. You do not have to, or you should not have to, develop or create some kind of paper trail in which you can show that you stuck around for more abuse. The paper that I presented suggests a definition of persecution that gets away from this language of pressing and persistent or sustained persecution, and it comes out of the Ninth Circuit Appeals in the United States, and it's a case called Hernandez-Ortiz. And in that case, the American court said that persecution was oppression, which is inflicted on groups or individuals because of a difference that the persecutor will not tolerate. Now, I don't think you're ever going to decide on the perfect definition, but what I do like about that definition is it takes away from, or it gets us off the focus of this pressing and sustained and systematic requirement. I would submit that there are certain types of persecution that do not require any pattern of abuse, and I'm talking about what James Hathaway refers to as his first-level core human rights, and these are things where, like threats to life and liberty, torture, cruel and demeaning treatment, arbitrary arrest and detention, all those sorts of traditional things that we've always looked to as amounting to persecution. Having said that, there is also recognized to be a second level of human rights, which Hathaway actually categorizes in a third category. And these particular rights lend themselves to claims based on cumulative persecution. And these are the rights that I'm talking about, basically social charter types of rights. Rights to work, the right to medical care, the right to education, the right to proper housing, the right to engage in artistic expression. These social, economic, and cultural rights are very important, and I'm somewhat hesitant to say to talk about them in terms of first level and second level, because I don't want to give the impression that I do not think they're as important, because they are very important to people. And as Grall-Madsen points out, quite often the denial of those second level rights has a far more important effect on an individual than the denial of a first level right. Now, the difference between the two categories of rights is that with the first category, things like life, liberty, freedom from torture, and so on, there's an obligation on states to protect their citizens and the people within their boundaries from a violation of those rights. With the second category of rights, it's not that there's an obligation per se, but certainly states who sign covenants and international agreements talking about the right to an education and the right to adequate housing and so on are agreeing to work towards the attainment of those rights. With regards to cumulative persecution, it's possible to lay a basis for persecution when you're dealing with these rights, because quite often when they are denied, it's in the form of some type of discrimination. It generally involves past persecution, and certainly the idea of cumulative persecution also suggests some kind of repetition or pattern. So I would submit that in terms of dealing with cumulative persecution, you probably do need to show some kind of a pattern, as opposed to when you're dealing with the first level rights, when I'd say you should not need to show the pattern. When dealing with a claim of harassment or discrimination, it is not sufficient to come within the definition to show only that the discrimination exists. You must go further and show that it's serious enough to amount to persecution. And when I'm talking about socioeconomic and cultural rights, what I'm basically saying is that it's not that governments must provide all those things like full employment and education for all. But when they undertake to commit resources to programs, they cannot do it in a discriminatory way. And if they do, it may amount to persecution. Now, in my paper, I referred to 4 or 5 federal court decisions, and I described them in quite a lot of detail, so I don't intend to go into them in detail here. But I would say the 3 most important ones dealing with cumulative persecution at the present time are the Retnam case, the Maladat case, and then a very old case, but it's a wonderful case. I trot it out almost at every board meeting, or every board hearing. It's called Oyarzo Marchant. And you can work that into your submissions in a lot of different ways. The basically, Oyarzo Marchant says that you may have may have a lot of things that happened to you in your past, and then you may have a period where there's not much activity, and then there's some sort of low-level harassment that starts again. And the Supreme Court was quite clear in federal court? Oh, sorry. Sorry. Okay. The court was quite clear in stating that you cannot divorce what happened many, many years ago from the persecution or the fear that you have today, that those things are all part of the whole picture. And Mr. Justice McGuigan in Retnam uses that reasoning to determine that even though, as Lorne was saying earlier this morning, what the person, the detentions and the problems that the person had several years before he actually left the country, when you added those onto all the other smaller discriminations and harassments that he had undergone since then, that amounted to a cumulative persecution. The other case, Maladat, is important because it also emphasizes the fact that even if the persecution or the harassment that you yourself have undergone is even if you have not yourself undergone that kind of harassment, if you can show that someone close to you or someone similarly situated has, you may be able to also make out a claim based on cumulative harassment. In Maladat, the person concerned actually did not have any incidences in her own past, but her children were denied education because of her husband's political activities, and her husband also had problems. So added all cumulatively, taken cumulatively, the effect was that this person suffered persecution. I just want to make a few comments about how the boards, how the panels are treating cumulative persecution, because they are quite willing to consider this issue. And I have looked at about 30 of the board decisions in the last couple of years. I can tell you that what is not succeeding at the present time is you cannot simply show up with your client and have the person give evidence that they're feeling real frustrated with the government, and there's this sort of unease in the air, and there's a lot of oppression going on, and so on and so forth. You have to have something more. This other stuff will just simply not fly. And you also have to be able to show that where there is discrimination, the board might accept that there's discrimination, but the question then becomes, is it sufficiently serious to come within the definition? And that's probably the tricky area, is determining what is sufficiently serious discrimination. Where cases succeed, the board has found that sometimes if you take a very serious harm plus a number of lesser forms of discriminatory treatment, you can make out a case for cumulative persecution. The Pakistan case that I gave you earlier is an example of that. And I also came across a case of a wife who was forced to undergo an abortion even though she had not violated the laws regarding one child, in China. And that, combined with a number of other acts of discrimination that the family had undergone, was sufficient to bring them within the definition. The second thing that the board looks at is what is the effect of all this discrimination and harassment on the person who is claiming. It's simply not sufficient to have a whole list of harms and add them up and say, there, that should be enough. You have to be able to show that the client has a real fear that has resulted from a buildup of fear over a period of time, and that each successive measure has increased the level of fear to the point that the person has finally had enough and has had to leave. I think that cumulative persecution is it's an important area because it's probably not gotten a lot of attention in the past, but it can be used quite successfully in a number of cases where you do not have these really startling traditional types of human rights abuses, and yet you do have a lot of harassment, a lot of discrimination, and if you can characterize it in the proper way and show that there is a serious there's been a very serious threat to the person over a period of time, you can perhaps be successful in showing that there's been there's a cumulative effect here and that this amounts to persecution. I would also, that's all I want to say, except I'm very sorry I can't stay. I do have to go in about 5 minutes, so if you can just excuse me when I get out.
Well, thank you. I think we should. I want to thank you now. Then that was very good, and thank you for the paper. And thank you for your presentation. Before I pass on to Clifford, I just want to mention one other case. It's in the digest at the end on the second. It doesn't matter, but you'll find it. It's right at the top of the second page. It's called Hassan. Remember that one?
Yeah, I've described it in my paper.
Oh, you did. Oh, you did it in your paper. But I love Hassan because Hassan is great.
You did, Hassan.
Has nothing to do. No, but Hassan, you see, the Hassan is a classic example of a whole series of things that happened to this poor fellow. Oh, it was a credible basis case, but the court said that he had enough to be a refugee, even though, and the tribunal rejected him as not having credible basis. And the court said not only does he have credible basis, he's a convention refugee. But the main thing was that there wasn't one major thing. It was like tragedy after tragedy after tragedy in this man's life that went on from when he was a little kid. I mean, it started before he was born with his father's business being confiscated and went all the way through his life, through university and everything. And so, I mean, it's a very useful case to show you how you can use cumulative harassment to win for your client. And the reason why we put it on the agenda was it's an area that I think a lot of people are neglecting, and it's the court. I think one thing I'll say, I think the court is slightly schizophrenic, you know? I mean, you've got Valentine, which says, you know, it has to be persistent and all that. But then you've got Madalat, which is like, you know, what happened to this woman in Madalat? I mean, her children were denied education. Her husband was arrested for 2 weeks, and they were under surveillance. And the court said the cumulative impact of these three things, none of which had happened to the person herself, except perhaps her surveillance, could constitute persecution. So I think that there is a shall we say, maybe a split, or however you want to, in the court. And I think some members of the court are much more open to a cumulative harassment type argument. And I think counsel should be aware that when you don't have this one horrific incident, that you should try and look at all of the other things. Now, since Madalat, the board has been saying in every one of their decisions, you know, we find there's that it's discrimination, but even cumulatively it doesn't constitute persecution. Well, I think that the real issue is where you draw the line between discrimination and when it leaps over the edge. And obviously, we have to wait for the court to give us guidance. Moving on to another burning issue in the area of persecution is persecution, prosecution, and Clifford is going to give a presentation on that. And I'm going to excuse myself for 1 minute because I have to worry about the agenda, and I'll be back. So I'm going to leave Clifford, and then I'm going to consult with the Law Society and tell you how many sandwiches we're having. No, I'm just kidding. Okay, go ahead, Clifford.
Thanks, Lorne. I'm going to be considering some of the major issues that are dealt with in Lawrence's paper. on persecution and prosecution, which you have. Am I audible? Good, good. The basic principle that we start with is that a person fearing prosecution... I thought I was audible. Okay, I am now. All right. A person fearing prosecution for a criminal offense, in principle, is a fugitive from justice and not a refugee. However, it may be that the process of prosecution itself constitutes persecution, and that is the central issue that has to be determined. Now, the approach that we suggest involves determining the issue in a number of stages, some of which are preliminary in a way to the central issue of whether the process of prosecution itself constitutes persecution. And the first of these issues is to look at the seriousness of the harm that the person faces. Now, irrespective of whether the other requirements are met, if the harm or sanction which the person faces is not sufficiently serious or is too trivial to qualify as persecution, then the claim cannot succeed, because the person cannot have a well-founded fear of persecution, irrespective of the nature of the prosecution process. And that, of course, has to be determined in accordance with the normal principles of persecution, which have been very well dealt with by Gladys, so I won't go over them. But that is a preliminary issue before you even look at the process of prosecution itself. Secondly, you have to determine the nature of the fear. And this situation will arise where a person has committed an act which might result in prosecution, but there are other elements as well in addition. And the question is the person in fear of prosecution only? That's prosecution in the broad sense, without assuming it to be legitimate prosecution. But is the person in fear of prosecution only? Or is the person in fear of prosecution and, in addition, some extra legal sanctions or extrajudicial sanctions which might constitute persecution? Or thirdly, is the person not in fear of prosecution at all, but solely in fear of extra-legal sanctions? And there are a number of cases which are dealt with in Lauren's paper in which boards have misunderstood the basis of the claim. They have failed to understand that the claimant is in fear of prosecution and, in addition, extra-legal sanctions which constitute persecution. Or, even worse, that the person is not in fear of prosecution at all, but merely fears extra-legal sanction. And there are a number of those cases. I'd like to mention really only the one that puts it in its starkest form, and that is the recent case of Addo, which Lorne argued before the Federal Court of Appeal successfully. And Mr. Addo's story was quite simple. He said, "I led a demonstration in Ghana against the elections. The object of the demonstration was to disrupt the elections. I was beaten up by the police and thrown in jail. My uncle, who was a police sergeant from another jurisdiction, came along to me in jail and said, 'You'd better escape quickly because the authorities are coming to kill you.' So, in time-honored dramatic fashion, I escaped from prison and fled the country." Now, the board looks at this and says, "Sorry, you're in fear of prosecution. What you would face is prosecution for breaching the electoral laws of Ghana," whatever they might be. It wasn't before the board. Well, as you might imagine, the court said no. The court said the board has completely misunderstood the basis of this claim. The appellant isn't in fear of prosecution, he's in fear of extra-legal sanction, i.e. death, and therefore Therefore, he's in fear of persecution, and therefore he's a convention refugee. And that presents the issue in a very stark form. But the important thing is to be very clear as to the nature of the fear, whether it's prosecution, extra-legal sanctions, both, or one or the other. Now, the third issue, if you determine that the claimant is in fear of prosecution only, that's prosecution in the broad sense, then you have to ask whether there is a link between the prosecution and the 5 convention grounds in the definition. Because irrespective of all the other requirements being met, if the prosecution is not linked to the definition, then the claim must fail for obvious reasons. And one can look at the prosecution to see if it links with the definition in terms of, for example, the motivation of the state in bringing the prosecution. Is it political in nature or persecutory in nature? You can look at the nature of the law to see whether it's designed to punish political opinion, specifically, for example, and you can look at the motivation of the individual in committing the act to establish whether there's a linkage to political opinion, race, religion, or whatever it might be. Now, if you then stand back from that and you've determined that the person is in fear of prosecution in the broad sense, the harm or sanction is sufficiently serious to constitute persecution, and there is a linkage to the 5 grounds, or one of them, then you get into the central issue as to whether the process of prosecution itself constitutes persecution. And here we suggest a number of issues, and Lorne suggests in his paper a number of issues that have to be gone through to arrive at an answer to this question. And the first of these is to look at the motivation of the claimant in committing the offense. For example, was the offense committed out of political motivation, and therefore prosecution would in effect amount to persecution on the basis of political opinion? Now, there's a definite divergence of opinion within the court on this question. And perhaps Sam will want to deal with that in a little more detail, but I'll touch on it briefly. The more restrictive interpretation arises from the judgment of Mr. Justice Pratt in the Musial case, approximately 9 or 10 years ago. And in this dictum, Mr. Justice Pratt said that prosecution for breach of an ordinary law of general application is not persecution, because the person is being punished for the offense which he or she has committed, and not for the political opinion which may have prompted the offense. In other words, there is insufficient link between the political opinion and the prosecution and conviction. Now, it didn't seem that there was a great deal of support, implicitly at least, within the court for that position for a number of years, and then in somewhat of a blast from the past, in the Valentine decision, Mr. Justice Marceau adopted basically the identical position, where he said that where you have a criminal law of general application, then there's insufficient linkage between the political opinion and the sentence for the sentence to constitute persecution. Now, there are a number, with respect, of very serious criticisms that can be leveled against this approach, and I'll deal with some of them briefly in a moment. But first, I'd like to note that there's another more liberal trend of opinion within the court, and that arises also from the decision of the Chief Justice in the Musial decision. And the Musial case concerned a draft evader and whether prosecution for draft evasion might constitute persecution. And the Chief Justice in that case said that prosecution for draft evasion does not necessarily preclude one from being a refugee. What you have to do is look at all the circumstances surrounding the prosecution, including the motivation of the claimant, i.e., whether that motivation was political and therefore whether the prosecution might constitute persecution. And there's been at least some implicit support for that position within the court. For example, in the case of Chamis, where the court held that refusal to serve in the South Lebanese army and sanctions resulting from that might lead to a well-founded fear of persecution. Now, looking at the position of Mr. Justice Pratt and later in the Valentine case, one of the serious criticisms of that position leads me to the next issue which needs to be determined, and that is the nature of the law itself. Now, the problem with applying a test of an ordinary law of general application without looking at its content is that you don't consider whether that law might violate international standards of human rights. And the argument here being that where the prosecution is in terms of a law that does violate those standards, then the process of prosecution should be considered to be persecutory in itself. Now, the argument is that there's support for this position at least in the way that courts look at persecution on an everyday basis. For example, a law providing for indefinite detention without trial is routinely held to be persecutory. Practices such as torture, condoned by the state, are routinely held to be persecutory. And the argument is that a law which provides for a criminal sanction, but which clearly violates internationally accepted standards of human rights, should be held to be persecutory, which would run contrary to that restrictive approach. Thirdly, one has to consider the motives of the state in bringing the prosecution. Now, even in the Valentine judgment, which was restrictive, the court accepted that where the motive of the state in prosecuting is discriminatory, then that would give rise, or might give rise, to a well-founded fear of persecution. And where the motive of the state is political, which obviously relates to that as well, the argument is that that also is an indication that the process of prosecution is in fact persecutory rather than being legitimate enforcement of criminal legislation. The fourth factor is the question of sentence. The argument here being that if the sentence is disproportionate to the offense, then that is an indication that the process itself is tainted with persecution. Now, as Gladys pointed out, in the Valentine decision, the court held that a sentence will rarely constitute persecution because it lacks the element of persistence which is necessary. Now, I would merely say with regard to that, with respect, that there have been a number of instances where the court has held claimants to be refugees on the basis of a single incident of persecution. Just off the bat, I can think of two recent cases. The one is Hilo and the other is Addo. I think Hilo may not be mentioned in the paper. The reference is A260 of 90. And in both those cases, the court held the appellants to be refugees on the basis of a single instance of persecution. And clearly, in our argument, the point is that if the single instance, in this case a sentence, is sufficiently serious to constitute persecution, then it meets the definition. There's also the question whether a sentence enforced in terms of a law that is again repressive should not be held to be persecutory. And if one looks at the jurisprudence at cases such as Babio and Cobbold, there's an indication from the court that where the sentence is disproportionately severe, or the punishment that it might be held to be persecutory. The next issue is to look at the status of the judicial system in the prosecuting country. And this is perhaps the most crucial of the issues. The point here being, would the person receive a fair trial in the prosecuting country? And there's clear indication in the case law that where the trial process itself would be unfair, then the process is persecutory and not one of legitimate prosecution. The leading case here is that of Satiacum. And in Satiacum, the court, among many other issues, the court held that a trial in a foreign country must be presumed to be fair. However, that presumption can be rebutted by evidence. For example, that the prosecuting country does not have an independent judiciary. Or if it does have such a judiciary, that there's evidence to impeach the total system of prosecution. Or, related, that the country is a known violator of human rights. And if there's evidence to that effect, then it might well be held that the trial process is unfair. And there's clear support for that in other cases as well. For example, the case of Cobbold, where the court held that a judicial system that was subversive of the rule of law, in the court's words, could give rise to a well-founded fear of persecution. Further, in the case of Camara, the court held that it was an undetermined legal issue whether mere prosecution could exist at all in the case where the prosecuting country had an undemocratic government and lacked a free and independent judiciary. Again, providing clear support for the argument. And finally, the other issue to be determined is to look at the human rights record of the prosecuting country generally. Now, clearly that relates as well to the question of a fair or unfair trial. But there have been cases in which evidence that the country is a known human rights violator has weighed strongly with the court in holding that the process of prosecution as a whole is persecutory. For example, in the Chaudhry case. I think the thing perhaps to point out in conclusion is that the issues which we've raised, these 6 points, are very closely interrelated and very often overlap. And what one should do is look at the process as a whole to determine whether it's one of legitimate prosecution or rather whether it's tainted by persecution. And those are basically the comments that I wanted to make. Thank you.
That's fantastic. I don't know what you're so nervous about it. You did great. I don't know. Well, that's fantastic. Thanks. Okay. Moving along. Sam has the unenviable task of responding to these 2 papers.
Thank you.
I should say that there are. Am I right in saying that there is the what's the paper on persecution prosecution is official board policy position?
That's right.
Okay, it's included in the material, and there isn't anything on cumulative harassment from the board, right?
There's one on cumulative discrimination, which basically follows the same intellectual.
Okay, but that we don't have that. I don't think we put it in.
Yes,
It
yes,
is.
yes,
It is.
you do.
Oh, sorry. All right. There. All right. I'm sorry. What I'm saying is, in the papers here, there's Gladys's paper. Then there's a paper on persecution prosecution. But in addition, you have the preferred position paper of the Immigration and Refugee Board. Now, that will be the subject of litigation at some later date as to what is the status of these preferred position papers. But it's in Chapter E. And then the one on cumulative harassment, do we know where that is?
It's cumulative discrimination. It's just following that.
It's just
It's in the same tab.
oh, it's
under
in the same.
tab. Yeah.
They're both together. Okay, so we have the 2 preferred policy positions of the board on these 2 issues, and both have the same status. Sam, they're both preferred?
Yes. Yes.
So for those of you who don't know, I'll just spend 30 seconds to tell you what that means. It means that the board has gone through a consultation process, has circulated these papers, and has come out with what they consider their preferred position, which are guidelines, I suppose, for members. Now, obviously, you can't fetter the discretion of members and insist that they apply them, but it's the position that the board would like to see its members apply. Is that a fair statement?
That's a fair statement.
Okay. No. So here's Sam.
Thank you. My remarks will be short. I just want to say something on the definition of persecution. I'll start with Gladys MacPherson's paper. As she notes, the element of persecution is central in the determination of any claim to convention refugee status, and neither the Immigration Act nor the 1951 Convention explains the meaning of the term persecution. And I would suggest, that the resulting uncertainty notwithstanding, that the lack of statutory definition of persecution should not be viewed as a weakness by yourselves, but certainly as its strength. It's an invitation for you to go beyond what you might quickly perhaps presume to be the parameters of its implications. It would seem that the definition of a convention refugee was deliberately formulated in such a way as to give decision makers, broad latitude in determining whether a particular act in a particular factual situation fits the meaning of persecution. As others have said more eloquently than myself, we have to provide for the new and ingenious modes of persecution that mankind will devise. Just a note on Gladys's comments regarding the perceived requirement for persecution to have an element of repetition, relentlessness, persistence, and so on. My response to Gladys's comment is that a well-founded fear of persecution is predicated on a serious possibility or reasonable chance that if returned, the person may suffer serious harm. Although the systematic or systemic nature of that of the incidence of persecution is an element which will contribute to the seriousness of that possibility. The attempt to establish or the decision to recognize or acknowledge refugee status should not turn on the presence or absence of one or many incidents of past persecution, but on the reasonable inferences that one might draw from the existence of past persecution to establish the likelihood of future persecution. After all, the definition has a prospective aspect to it, namely what the panel has to be satisfied is that there is not past persecution, but a well-founded fear of persecution were the person to be returned to his or her country of origin. So I would say that in your submissions, in your presentation, and I would invite you, I'm not speaking for the members, but certainly I would invite you to not focus so much on what you think is a prerequisite to a definition of persecution, namely how many times has a certain kind of harm been inflicted on the claimant, but rather on what this means to you and what this should mean to the decision maker in terms of the likelihood of this person suffering persecution in the event that this person is returned to his home country. In her paper, Gladys states as follows: "It is not necessary to demonstrate past persecution since what is being assessed is future risk, but where the claimant can point to instances of past persecution, he creates a rebuttable presumption that he may again become a victim of persecution should he be returned to his country of nationality, assuming that the same power structure is in place that was responsible for the earlier persecution. I don't know if it's the way that she's articulated this idea or not, but a red flag seemed to come up in my mind, and what I would suggest to you is that you not assume anything in your presentation, let alone a presumption or the retention of a presumption by the panel in fact, that the existence of this presumption. I think you should ensure that both the evidence you present and the submissions you make address the conclusions you like the tribunal to draw from any incidents of past persecution. Let me just say a few more comments. They may appear disjointed to you, but I think may all make sense. I think that what has to be retained with respect to the definition of persecution is that the dictionary definition of the term adopted by the court in Rajudin, coupled with the principles set out in the recent decisions of Salibian and Zalzali, clearly indicate that persecution is not established on the possibility of consequences of life and death proportions. It does capture a wide range of measures and sanctions which seriously affect one's physical, moral, or intellectual integrity. I think the question that has to be asked is what standard measurement ought to be used for identifying and evaluating the kinds of harms or injuries that are so severe that their imposition constitutes persecution. Gladys has suggested, and I fully agree with her, that international human rights standards, rights and freedoms constitute the most relevant standard, and that Professor Hathaway's four-level, and not just two-level as she suggested, but really four-level hierarchy of human rights is a useful, pragmatic approach to identifying serious harm. These are found in the preferred position papers and are known and looked at by the members at the IRB. I would only add a couple of comments to what Gladys has already mentioned in the treatment or application of what Professor Hathaway provides us, and that is that a discriminatory measure or sanction imposed as a penalty on the exercise of a fundamental human right may amount to persecution. And here I would invite you to look at this from three ways. One, because of the particular importance attached to the particular human right violated, i.e., how far up is it in the hierarchy of rights? Is it a higher level right, or is it a lesser right? So one is a particular importance attached to the particular human right violated. Secondly is the particular gravity of the violation, and this in particular when looking at lower level rights. And thirdly, the cumulative grounds that Gladys has mentioned. It's evident that certain incidents which considered individually do not amount to persecution may nevertheless produce a cumulative effect of sufficient severity that they could rise to the level of persecution when considered together. That's really all I have to say with respect to Gladys's paper. With respect to Clifford, I found the paper presented by Clifford excellent, both by its thorough coverage of the applicable jurisprudence and the interpretation that he derives from that jurisprudence. So I don't have a lot to tell you. I would invite you to look at your binders at the preferred position paper issued by the board on the same issue, and really, other than a rearrangement of the sub-issues in terms of form and focus, really the substance is pretty well comparable. I would say that we are in agreement with the paper's conclusions. I would just perhaps take a couple of minutes of your lunchtime to talk to you a little bit about the prosecution and prosecution as persecution as it relates to draft evaders or conscientious objectors. The board intends to issue shortly a brief paper on its position regarding basically the following question: under what circumstances may refusal to perform military service by either evading draft or deserting a force lead to the recognition of convention refugee status? So we're dealing with a particular fact situation under the rubric of persecution, prosecution as persecution. Just a very brief preview, and that is that our point of departure is that prosecution and punishment for refusal to perform military service does not in itself constitute grounds for a well-founded fear of persecution, but that certain circumstances may provide a basis for the recognition of that status. And we basically recognize three grounds of objection to performing military service. For convenience and sake, we call these conscientious objection, selective objection, and discrimination-based objection. Conscientious objection we define as a refusal to bear arms under any circumstances on the grounds of pacifism or unconditional respect for human life, and the legitimate exercise of one's right to freedom of thought, conscience, and religion. Where a conscientious objector has been drafted into compulsory military service, and the claimant's country of origin does not provide for an exemption from military service, either entirely or subject to the performing alternative service or civilian service, then assuming the claimant's professed beliefs or convictions are shown to be genuine, such a person is a candidate for refugee status. Secondly, by selective objection, we mean the objection to participating in a particularly illegitimate or unacceptable military activity under international law, or to serving in a particular war that directly affects the claimant's identity and human dignity. Such activity would include military activity that is fundamentally illegitimate in international law and that it violated international human rights law. It contravened the Geneva Convention standards for the conduct of war, or it involved external aggression in violation of the United Nations Charter. In other words, is a military activity that has been, that had been, or was susceptible to being condemned by the international community as being contrary to basic rules of human conduct. And thirdly is the discrimination-based objection. Here we refer to an objection to a military service system having a legitimate purpose, but nonetheless established or administered in a discriminatory manner in relation to one of the grounds in the Convention refugee definition because of, for example, discriminatory conscription, targeting certain groups, and so on and so forth. So that's where we're at. And I'm not going to go much further because I know you want to go and have some lunch. Thank you.
Thank you. Well, I'm in your hands. You have two choices. You can ask questions or go for lunch. Okay, 1 hour exactement. And I'm sure that's no reflection on our speakers, but on your hungry stomachs, right?